Hi everyone and welcome back to the University. Today we have day 14 of the Raymond Davis trial. This is September 12th, 2019, and we start off with a motion to recuse Judge Bluth. This is heard by Judge Jones. And I got some very Breathless Mahoney vibes from Raymond Davis during this trial. Very Dick Tracy 1990 film. If you've seen the film, you know what I mean. And don't come for me, it's a good film. And then afterwards, we go back to Judge Bluth's courtroom and we have a motion for a psychological evaluation. This was spicy, in my opinion. Let me know what you think in the comments, all right? Hope you enjoy.
Your Honor.
Morning. We're on the record. If you guys are ready, are you guys ready? I'm sorry, I just kind of rolled in there. I didn't know. You guys ready?
Wait for Mr. Klaus.
Okay. You
Can I
have,
just check on him, Your Honor? He's not out there yet.
okay, thank you.
Judge, would you like me to stay on or wait till Mr. Foster?
Give me a look. Mr. Klaus.
We're on the record?
Yes. Okay, we're gonna go on the record and see 342-946, the state of Nevada versus Raymond Davis. Mr. Davis is present representing himself. Mr. Klaus is here, standby counsel. Ms. Collins is here on behalf of the state. So this is on for a motion to recuse Judge Bluth. And Mr. Davis, it's my understanding that you made an oral motion yesterday to recuse Judge Bluth?
Yes, Your Honor, and I wrote one out, and I'm trying to get it for you. And that's why I'm frantically going through all of this. I basically know what it says, but it was... I definitely just had it in the lobby. Got so much paper.
Okay, well, sir, let me just say this, okay, we need to function off of we need to operate off the oral motion that you made, because Judge Bluth is required under the statute to file an affidavit. She did file an affidavit, however, her affidavit is based on what you said yesterday. If there's anything additional in this motion, she has not had an opportunity to respond to that, so I can't rule on any additional things, as she has not responded. Do you understand?
Yes, Your Honor.
Okay, so can you tell me what was the basis of the motion to recuse that you made yesterday?
The motion was based on the District Attorney Stacey Collins and systematically eliminated all black males from the pool.
Okay, well, Judge Bluth's affidavit is based upon you making a motion about a witness list and you making a motion about, there was a witness list as well as all of your motions having been denied.
Yes, also,
Okay, we can't add anything, sir. I'm only here to rule on those things, because those are the things that Judge Bluth has responded to, so those are the only things I know about. Okay?
Yes, Your Honor. So, I had counsel, Craig Mueller paid counsel.
Okay?
They were ineffective, so I removed them and became pro per.
Okay?
I was in offer a deal from the state with no jail time and just don't go to trial. I exercised my right to a trial. I said, I'm not guilty of this. Since then, Judge, even before this, Judge Bluth has been showing prosecutorial favoritism to the prosecution, so I felt that I could get a fair trial, so I asked to recuse her because, and then the witness list came up, and Whenever the juror was seated, the DA challenged my witness list, told me I couldn't go to court with a witness, so I would be defenseless. When I plainly, Craig Mueller gave her a witness list, she has the witness list. She had the witness list 2 months ago, and she acknowledged, even the judge acknowledged that she knew she had the witness list. She says it was signed right, and she says now you have to, not only do you have to face a juror with basically not one black male, which I am African-American male, proud citizen of the United States, served my country. So I have to go. So I have to go to court without witnesses. So I cannot defend myself. I had a mental breakdown in court yesterday. Three other jurors had a mental breakdown because the judge had them recount sexual assaults. As they were kids, at 7, I was sexually assaulted by in a foster home, and the state did nothing. So, but I overcame that. I became a businessman. I haven't been in trouble in years. And then these allegations come. So I'm in court. I provided a witness list, and then last night, obviously I broke down. I broke down at 12 o'clock last night. I went to the mental hospital. It's on record to check in. And they put me in a room for several hours. And then they said that my blinker, which they put on me, started going off.
Is that your house arrest?
Yes,
Okay.
it started going off. The doctor says, you gotta stay here. I said, I can't, they're gonna arrest me if I stay here. I had to go home. My friend came over to consult me all night. I haven't been asleep because of what they're trying to do to me. Yeah, so I said, the doctor says, you gotta have to come in and see me because Mr. Davis, you're not in a proper frame of mind. I don't want you to do something to yourself. I want to evaluate you. And I said, I have to be in court at 9. I said that they're trying to railroad me. I had no help. She just, everything, she says it's not there. You can't do this. You can't have a black, I can't have a black man on my jury. I can't call a witness to defend myself in the court of law because she says it wasn't notarized notice to the court. I never heard of something like that. I'll be totally defenseless.
Well, that's the law, sir. I mean, the law under NRS 174.234, you have to file a witness list 5 days before trial. Ms. Collins has to do that, and so do you. That's the law. Judge Bluth has no ability to go around that because that's the law and that's what the law says. And sir, I don't know what Mr. Mueller filed in this case. I'm not here to decide any of that stuff. Any witness list that was filed timely, I'm sure Judge Bluth will allow those witnesses to be called. But it's my understanding you attempted to file a witness list yesterday afternoon. That's not timely. You guys are in the middle of trial. So any witness list that wasn't filed more than 5 days before trial, Judge Bluth cannot allow that. So that's not a legal basis for you to recuse her because she's citing the law to you.
Your Honor, I didn't attempt to file a witness list yesterday. She had the same witness list I had for 3 months. I had the same witness list that Greg Mueller had. It had all the witnesses, none of them changed. She had it in her file when she gave it to me. So many witnesses.
Who is she?
The DA.
Okay.
She had the same, Stacey Collins had the same witness list. None of it had been altered.
Okay, well, sir, I'm only here to address what happened yesterday. I don't know what Mr. Mueller filed. This is not my case. I don't know anything about any of that. But it's my understanding that Judge Bluth's citation, NRS 174.234, is the law. She has no ability to go around that. So if Judge Bluth is citing to NRS 174.234, she is following the law, and there's no legal basis for her to go around that. So that is not a basis for you to recuse her. So your motion to recuse Judge Bluth is going to be denied, and I believe you guys have trial coming up.
Your Honor, can I get a mental evaluation, please?
Well, that's going to be something for Judge Bluth to decide, sir. I'm only here to decide the motion to recuse.
Thank you.
When Judge Bluth takes a vote, you can address that with her.
Thank you, Your Honor. I
Thank you.
appreciate your time.
Nevada versus Raymond Davis. Mr. Davis is present. Standby counsel, Mr. Klaus is present. Chief Deputy District Attorney Stacey Collins is also present. It's my understanding that the motion to recuse was denied by Judge Jones. It's also my understanding Judge Jones stated to me that, Mr. Davis, you're requesting to have a mental evaluation?
I went to the hospital last night, to the mental hospital, to get screened to a place that I want to pay for myself. I don't want no state treatment because I can afford my own medical treatment. I went, sat there in a screening room at the behavior, you can check the records, the behavior mental clinic, because you have pushed me, this court has pushed me to an edge where I was very dangerous last night, and I wanted to do something and be very dangerous, and I couldn't sleep, and my mind was telling me things. So I said the best thing to do is drive yourself to the mental hospital, get an evaluation, calm down. They put me in a room about an hour and a half. The doctor was said, I'll be with you in about an hour, Raymond, because we had other patients. My ankle bracelet started going off. I said, I got really violent with the staff. I apologized to them. I said, not really violent, but just loud. I got real loud with them. I said, I apologize, I cannot stay here. I must go back home or else I will be arrested because my monitor is going off and the police will come and get me. They said, Mr. Davis, we want to screen you first. Then we can screen you tomorrow at 8 o'clock. I said, I cannot be screened at 8 o'clock. I have to be in court at 9. I said, tell the judge that you need to be screened. We will give you a mental evaluation. You can come back with the court. I have never been so mad in my life. What this court is doing is called railroading. Not to take every black out of the jury, to take every black male out of the jury, to take, to say, I cannot have any witnesses to defend myself.
Okay, we're going to correct the record right now because you continue to lie.
Okay.
So tell me which African-American male I kicked off the jury. You go ahead and tell me that. Which one?
I didn't say you kicked them off.
You said this court.
No,
So tell me which
I
one.
said there is no African-American
And
male.
should I make them magically
I
appear?
said there is no African-American.
Do you want me to make them magically appear?
You made me magically appear.
I make you magically
Yes.
appear?
Yes.
Okay.
Yes. So I need a mental evaluation, and I want to do it on my own because I want to pay for my own doctors.
Okay. And Ms. Collins, do you have any representations to make in regards to what Mr. Davis is stating about what was going on with him last night and how he was feeling about what he wanted to do?
I don't have any representations. I can tell this court just from my observations from the inception of when we've been in here, the reporting to the FBI, the volatile behavior, the breakdown yesterday. I've had concerns about his competency that I think I voiced day one, so I have no representations to make about what treatment he sought last night. I can tell the court that he made a lot of representations to Judge Jones about how the trial was transpiring, the state purposefully excluding African-American males from the jury panel, things that just didn't happen yesterday. So that obviously causes me concern about his ability to accurately perceive, digest, and relay what's going on around him. I don't think he is probably at the best capacity now to
And in
pursue the
regards
trial.
to his representations that he wanted to do something very dangerous last night,
Well, obviously that causes the state concern. I mean, he has been hyper-focused on what I have done to, torpedo or taint him or give him an unfair trial. He's talked about Googling me. He's been to the FBI about me. When he says he wants to do something very dangerous, if he's actively dangerous, of course that causes me concern. Causes me concern for my witnesses, causes me concern that he may self-harm. I mean, I don't know what I do have some record of him being violent in the past, but it's in the far past. I can't say what he's going to do, but of course that's concerning to the state. I mean, if he's going to get comped, my request would be that he be remanded and comped by doctors of this court so that we get reports and we know what's going on. So.
Your Honor, I have no violence on my record.
you just talked about you were gonna do
Your
something
Honor,
incredibly dangerous.
Your Honor, I said my mind, if I was dangerous, or if I thought I seeked help at 1 a.m. in the morning, I got out of bed, I drove to the hospital, and I checked myself in. I checked myself in, so that's how you de-escalate a situation. So I just got out of bed, I said, I'm not, the anxiety and the anger in me wasn't to go out and ram somebody's car or shoot someone or do bodily harm to anyone. I felt that I was at a point in my life where I was having a breakdown, I couldn't breathe, I couldn't eat, so I said I need to seek medical help. So I got in my car and just drove to it. I didn't
That's
speak.
completely different than what you just represented to the court 5 minutes
No,
ago.
I said-
No, let me talk. You said you were thinking about doing something very dangerous. You were worried about what you were going to do, so this is what we're going to do. The defendant's going to be remanded into custody. I have great concern in regards to the representations that he has made today in regards to what he said that he was going to do. So the state's motion to have him remanded for purposes of an evaluation will be done. I will have that evaluation done this afternoon.
Why can't I have my own doctor? Why do I have to have state doctor?
So I will have the evaluation done, hopefully at the jail this afternoon. And the evaluation, depending on the results of the evaluation, if the evaluation comes back as, I don't want to say clean, but what I'm saying is if the evaluation comes back in regards to the defendant is being malingering or being manipulative to get out of a trial, then we will continue the trial tomorrow at 10 a.m. If the doctor believes that there are some competency issues, we'll address that tomorrow outside in front of the jury at 10 a.m. So I will call over to the jail right now, and I will attempt to get the evaluation set up as soon as I can. So obviously, would you have a problem taking register class?
Not if you, not.
No, I want to keep my own record. I need to go with my
What you do is put into your property, within CCD.
Okay, put it in the property. That's fine.
Okay, that's fine. We'll make sure that it's all put in with his property, and I'll go contact the jail and make sure an evaluation is done as soon as I can get that done.
Your Honor, if that is, just for the record, if that's not able to be accomplished, the state would be requesting formal competency proceedings so that we have documentation on file that he is competent for court standards.
So, yeah, and I'll have that done. We had this happen a few trials ago, the same exact thing, and the doctors provided a report discussing the findings. So it actually is something that happens somewhat common, but we'll have the formalized paperwork either way. All right.
You're on the record.
We're on the record in C-342946, State of Nevada versus Raymond Davis. So I just want to make a record. My marshal had approached me and let me know that before I had come on the bench. And Marshal O'Kelly, could you reiterate what you had stated to me?
Yes, Your Honor. Shortly before you took the bench, Mr. Davis made a statement that he would not continue with this jury and that he had an intention to go off in front of him. I warned him that that would not go well with him. He indicated he didn't care, all due respect to me.
All right. So, as the record has already shown, Mr. Davis, I believe, is trying to manipulate once he saw that he wasn't getting every single thing he wanted, that he is trying everything he can at this point to get what he wants. He has told this court that he's going to leave and get surgery on Monday because his house arrest bracelet is bothering him. He provided a doctor note that said he had slight bruising. I offered him to get him a new anklet, a new ankle monitor, and put it on the other foot. He told me he refused that request. This jury has 8 African Americans. The state did not pick 1 African American. When he is very upset that there are no African American males on the jury. I do note that there are 2 that are alternates. When he tried to file a witness notice late, I explained to him, the state objected, I explained to him that I was happy to consider him filing it late, but I just needed him to show good cause. He also flew off the handle of that. And so I believe that these are all strategies that he uses to get what he wants. As soon as court was over yesterday, he pretended to call Governor Steve Sisolak on his cell phone. I think he's a very, very manipulative human being that will use whatever strategies he can to get what he wants. And so if he, in fact, does have some competency issues, we're happy to get him the help he needs, but we're going to need that evaluation done, and I'll go make sure that those arrangements are made right now. Does anybody have anything else to add?
No, ma'am.
Okay, all right, thank you.